नमस्कार, द रेड माइक में आपका स्वागत है। मैं हूं संकेतुपाध्याय। अभी कुछ दिन पहले सुप्रीम कोर्ट में इलेक्टोरल बॉन्ड को लेकर के एक प्रोसीडिंग चली। उसमें बहुत सारे वकील उठ खड़े हुए और अपनी अपनी दलील दे रहे थे। उसी में से एक वकील थे मैथ्यूज नेदुम्पारा। सबसे पहले तो आइए हम आपको सुनाते हैं कि सुप्रीम कोर्ट में उस दिन हुआ क्या। मैथ्यूज नेदुम्पारा जो कि एक वकील हैं, जो कि वकालत कर रहे थे, उन्होंने कुछ बोला और वो किस तरीके से तीखी नोकझोंक की तरफ चला गया। आइए पहले वो सुनते हैं, फिर आगे बढ़े।
Yes. Now, my submission is the entire judgment has to render behind the back of the public at large. This judgment doesn't constitute justificator. This doesn't constitute constitute justificator.
One second.
Yes.
1 second.
This judgment is void.
Please listen to me. 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a hyper corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No,
File an application. What I told Mr. Rodgi applies to you.
No, my lord, the question is, my lord,
No question.
My friend has come.
Mr. Nedumbara, 1 second.
Yes.
You got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court.
No, we will go by what you are watching on, please. Whatever you are watching, that is go by that.
You want another contempt notice?
No, my lord, your worship will go by whatever you want to say.
Bombay.
No, only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't constitute us. It is not a do not sit on.
Please, once we have said no, please move that.
But your lordship says,
Do not continue and persist.
Yes, I only said it was not a representative proceeding.
But you are obstructing in the administration of justice.
Pardon, my lord?
You are obstructing in the process of administration of justice.
The entire judgment is against behind the back of these people. Parliament has been rendered.
That's all. That's all. We heard that. Please, that's all. Please, you made it. We will not hear you till you move follow the procedure prescribed.
They are finding it.
Please do.
They are finding it.
Please do. We'll consider it afterwards.
This started at 10 o'clock.
I
Friend came from Kerala. We took a 1 o'clock flight. Be kind to us. Be kind to us.
don't please, we will not hear them. Then there will be a solve for the applicant. Please follow that here.
तो ये जो आपने बयान सुना, ये जो नोकझोंक चल रही थी, ये थी एडवोकेट मैथ्यूज नेदुम्पारा और सुप्रीम कोर्ट के जजों के बीच में। उन्होंने अपनी तरफ से दलील ये दी, ये कहा कि ये जो जजमेंट है ये सब लोगों का प्रतिनिधित्व नहीं करती है, ये लोगों की मर्जी के विरुद्ध आई है, उनके पीठ के पीछे आई है। वी आर इन अ डेमोक्रेसी, लोकतंत्र में होने की उन्होंने बात कही। ये सब तमाम बात वो अपनी कर रहे थे। मैथ्यूज नेदुम्पारा जी जो हैं वो अब हमारे साथ हैं, जरा स्क्रीन पर उनको आमंत्रित करते हैं। मिस्टर मैथ्यूज नेदुम्पारा, थैंक यू वेरी मच फॉर जॉइनिंग अस। What language would you be comfortable speaking? English?
I'm only English. I'm so
okay.
sorry.
Not a problem, not at all. My first question to you is, Mr. Matthews Nedumpara, you see, a judgment had already been delivered. You went there on the third attempt of this constitution bench in order to, that is post judgment, where in the third round, the constitution bench was trying to get its order implemented. And at that time, if I've heard you correctly, you say that this judgment has been rendered behind the back of the people. Mr. Nedumpara, I want to understand which court judgment goes according to a public referendum. Is that the court's mandate to give judgments based on public opinion, that it is at the back of the people?
There is a difference between a judicial function and a legislative function. When the parliament enacted law, we are all symbolically present. It is with the consent of all of us a law is enacted. Therefore, we say a record of a court is binding on all. On the contrary, the record of a court is only binding on the parties before it. And if in a case between A and B, a particular aspect is decided, then that judgment will be binding only A and B and nobody else. And there is one exception to that. That is in the case of the judgments called judgment in drum. Judgment in drum will be binding on even those who are not parties. And the principle is founded on the public necessity, public interest. For instance, in a case between a husband and wife for divorce, if divorce is granted, that is a judgment in drum, and that is applicable as against the whole world. And the husband and wife thereafter are free, and any person who enter into a contract of marriage will not be committing, an offense. On the contrary, if a divorce is rejected, there is no change of status, and the judgment is in persona. This is the only exception where a judgment could be binding on a person who is not before the court. And in all other respects, no court has the power to render a judgment which is binding on the persons who are not before it. And the question is,
No,
other
but Mr.
exception-
Matthews Nedumpara, you see, the thing is that all those people who were party to this case, the government, State Bank of India, right? They were all questioned. They all appeared, and a judgment was delivered. Now, suddenly, post the delivery of this judgment, big corporate houses represented through their industry bodies, individuals, and all those people who think that this judgment was rendered behind the back of the people come up with their representation. I think that is the point which was being raised by the court. Now, if there is, for instance, take for instance the role of the industries, like corporates. They say it is affecting us and our privacy. Now, they knew for the past 5 years that this matter was going on in the court, in the Supreme Court. They could have asked for they could have filed an intervention application that we too must be heard, but that never happened. So, post judgment, what is the great joy in doing this and getting scolded from the judges?
Let me answer. See, I'm talking pure law. And when a law means there's a principle behind it, a democratic principle behind it, a legal principle behind it. As I told, no court has the power to bind the persons who are not before it by his judgment. Another exception is the called representative action. Representative action is assuming in a case where a large interest of a larger number of people are involved. There are one or more persons, with the permission of the court, can institute a representative proceedings, and that judgment in a representative proceedings will be binding on all who are before it. And for a representative proceedings to be instituted or continued, there has to be a notice has to go to every person whose rights are infringed or one way or other affected. Or when the numbers are so numerous, there has to be a publication, a paper publication. The public need to be told that a proceedings has been instituted, and if you are concerning, these are the prayers sought for in the petition, and you must seek you are free to oppose or support it. That is a representative suit. Whatever is done in the name of PAL is against the basic tenets of law. And for a court to declare,
which is why what I am asking, Mr. Nedupara, when you say that it should be made available to the public, I have not heard of any judgment being delivered in a court of law which involves or invokes the opinion or the sentiment of the people. I mean, that's...
Let me answer this. This business of PAL has been going on in this country for last 30, 40 years. It is absolutely illegal. It started as a pro bono litigation, and that was perfect. Pro bono, kindly listen to me. Pro bono litigation, there exists a person aggrieved. Suppose that you are moving an application or filing a petition for the release of a man and under trial. Then the real petitioner is not sanketupadhyay. The real petitioner is the A in jail, who out of his poverty, illiteracy, is unable to approach a court. And here the prisoner under trial through is moving an application. Where exists a petition? It is for the enforcement of a private right, fundamental right of a person. Through the
fair enough. Mr. Nedumpara, I understand what you're saying. See, but the point is, doing this at the very last minute, doing it at a time or invoking all these provisions or coming to the court with your prayer when a judgment has already been delivered. And
No,
the
if a
court is
judgment-
saying, the constitution bench is sitting for the third time post its judgment, where it
No, no.
wants its order to be implemented.
No,
And that
one
too in an
second.
oral submission.
No, but there is another aspect. See, the judgment, as I said, is rendered behind the back of the people and behind the back of the people affected. So it is concerning some people purchase the bonds, and this judgment, none of them were parties to it, none of them were heard, and then no publication was made. So therefore, the judgment is rendered behind I don't hide the fact that see some of the donors had approached us to be represented, and therefore their grievance is that judgment has been rendered entirely behind their back, affecting their rights. That is one aspect of it. Another aspect of it, the electoral bond issue is a matter of legislative policy. Legislative policy is not justiciable. This mistake, this grave error of the court acting beyond the jurisdiction in violation of the basic principles of natural justice, elementary principles of judicial procedure, and making a very serious allegation. Acting contrary to the elementary principles of judicial proceedings has been going on for long. I take the instance of NJAC case. NJAC case, who can come to the Supreme Court? A person whose fundamental right is infringed. Nobody else. You can't enter the portals of the Supreme Court invoking Article 32 unless you claim and establish that your fundamental rights are infringed. And the petitions after petitions have been filed in the last couple of decades by the people, busybodies, invoking Article 32, and such petitions are entertained by the Solicitor General.
Mr. Nidumpara, are you trying to say that it is not in the mandate of the Supreme Court to be listening to these public interest litigations and then giving their judgment?
Absolutely, absolutely. The court has no jurisdiction, and the Attorney
What
General,
you're saying?
Solicitor. Yes,
I mean, then what is
disagree.
a five-judge constitution bench has no right to deliver a decision?
Let it be 34 judges sitting together. If they don't have a jurisdiction, they have no jurisdiction.
You think they would not know? The highest court of the land will not know what their jurisdiction is.
See, I must respect the judges, therefore I don't give a direct answer to that. I will only say indirectly, it is a duty of the Attorney General, Solicitor General, to point out to the court these are not justiciable issues.
No, Mr. Nidumpara, you see the problem is, and the way you are making your arguments, you also post saying what you did when you were told to not shout at the Chief Justice of India.
No,
you said the Parliament.
Yeah.
No, I'm quoting the Chief Justice. He told you that don't shout at me. This is not a Hyde Park corner meeting. Now, Mr. Nidumpara, Mr. Nidumpara, you also told the court that the Parliament has become irrelevant. This is a democracy, right?
Yes.
Your conclusion was that Parliament has become irrelevant because of this decision of the court, and this is a democracy. It almost appears to me, Mr. Nidumpara, that you conclude that the Supreme Court of this country is not part of a democratic process, and that only Parliament and Parliament-based decision making is what constitutes Indian democracy.
No, let me answer it.
Now, is that not completely incorrect?
No, let me answer it. I'm a lawyer. I respect the institution of judiciary, and when I say that, suppose a court today it's a convict an innocent man as find him guilty of murder. Innocent man, the court find him guilty of murder, and send him to the gallows. And the Supreme Court is wrong, but it's right. The Supreme Court is sovereign. Supreme Court is supreme in its domain, in its exclusive jurisdiction. Supreme Court, yes, he can send an innocent man to the gallows, finding him guilty of murder, and there erroneous decision is binding. Erroneous decision which even takes away the life of a man.
No, Mr. Nidumpara, you're not answering my question. See, there is a reason why it's called the Supreme Court of the country. Ultimately, if you exhaust all your legal options, your final call is the Supreme Court of India.
Let me complete it. Supreme Court is supreme and final. Even its erroneous decisions are binding in its domain, where the issue is justiciable. Like that, in matters of policy, these courts have no jurisdiction. Electoral bond may be a very bad idea. It may be leading to corruption, whatever it be. Assuming that's a very bad idea, then that is a matter of policy. It is for the parliament to correct it. If the current government is bad, it vote it out from and bring completely repeat the law or amend the law. It is all within the legislative domain. That is the will of the people. You must see the distinction between the what is a justiciable issue. Every lawyer knows what is a justiciable issue. There must be a definite right. There's definite cause of action, which is
Mr. Nedumpara,
ascertainable.
I get what you're trying to say, but I think the fight over here is the right of the corporates to keep their identities protected via a law or a policy versus the right of the people of the country to know. And they have to coexist. One cannot be on top of the other. So while the corporates have the right to donate to political parties, at the same time, the people of this country have a right to know about that donation, right?
No,
I guess what this judgment has done, it has struck that fine balance between these two things.
Now I tell you, say I partly agree to that. On the question of this electoral bond issue, certainly involves corruption, and I am the last person to support anything which is involved in corruption. But what I focus is that the practice of the court, entertaining or entering into the domain of the policy has been going on unquestioned for many decades. NJAC case is a classic example. Whose fundamental right was affected by the NJAC? Nobody claimed that nobody claimed that his fundamental right is affected. It is a purely matter of legislative policy as to how the judges of this country are to be appointed. And such a petition was entertained, and the will of the people was subverted. Therefore, if this country we cannot even constitute a national tax tribunal, because the Supreme Court said that is unconstitutional on a petition of whom? Certain vested interests of lawyers. So therefore, you must make a clear distinction that exists everywhere. Pro bono litigation is absolutely legal. There exists a person aggrieved, and the court is entertaining a petition at the hands of another for the enforcement of the fundamental rights of a man using the public law domain, public law remedy. Pro bono litigation, I am 100% with you. But PIL is an abuse. PIL is to obtain an order at the hands of the court behind the back of the affected people.
No, but my point is, Mr. Matthews Nedumpara, a public interest litigation, and I have heard you as well as Mr. Tushar Mehta making this claim post a judgment and the Supreme Court trying to enforce its judgment in 3 sittings post the judgment. I think one really wonders whether that was the right forum to make a point, however just. Now, my point is, and my final question, Mr. Nedumpara.
Let me answer to this question very briefly. See, if a judgment is void, nullity, it never ever exists in the EF law. It can always be questioned. And secondly, the mechanism to question is...
No, that is you are saying that it is void, no? How is the judgment void? It is your conclusion that it is void.
No, it is not, in my opinion, it was not a justiciable issue at all. It's a policy decision. Right or wrong? Absolutely wrong. Parliament is right when it is wrong. Court is right in its domain even when it is wrong. That is a distinction. You have to add this. This is the whole failure is because the Attorney General and Solicitor General did not raise the objection that the issues are not maintainable. It happened in many times. NJAC case, the solicitor.
Now my final question to you, Mr. Nedumpara. You see, in 2019, you were guilty of contempt when you had given an undertaking that you will never again, and I quote, attempt to browbeat any judge either of the Supreme Court or the Bombay High Court. You were then sentenced to 3 months imprisonment, which was suspended if you promised to abide by your undertaking. Do you feel that, and the criticism here is that Mr. Nedumpara does this for publicity, that he is then talked about. How would you respond to this?
No, I will say that I hope Justice Maniman owe an apology to me. He convicted me for contempt of court without a notice to me, without hearing me, in my absence, without a lawyer. It is against the base. It is against the constitution. It's against the first principles of natural justice. No court has the power to convict a man, sentence him to jail without a notice to him. Without a notice to him. And the greatest of, because why he did it? I challenge the practice of the Fadi Nariman in the Supreme Court, where his son is a judge, and even when Fadi Nariman is involving in matters where the collegium of which his son is a member, he is supporting that. He is supporting those matters. Therefore, I filed a petition in the Delhi High Court challenging the explanation to Rule 6 of the Bar Council rules. And the Bar Council rule says that a lawyer shall not appear before a court of his immediate relative is a judge. And that is the Bar Council rule. You cannot appear in a court where your immediate relative is a judge. Then this explanation, which I question, says that the court does not mean the entire court, but a particular judge or the particular bench of which the relative is a member. So that is the issue. So therefore, I stood for transparency. And this, what is, look at that. The judges appointing themselves system has led to the entire judicial system. Reduced to the it's a nepotism, kith and kin, nobody else. Look at the senior judges of this.
Okay, it seems, Mr. Nedumpara, that you're positioning yourself as a self-appointed course correction activist for the judiciary in this country.
No, I have been active against corruption for the last 20 years. 20 years. 20 years I have been I have been attacked, I have been persecuted, but I have nothing against whoever has harmed me. Nothing ever. I believe in the philosophy. One last word, sir. In the philosophy of Christ, Lord, forgive them, for they don't know what they are doing. I will have nothing against whomsoever has harmed me in whatever way. And I believe in a democracy. A citizen has the freedom of speech. Freedom of speech, the right to dissent. I should have the right to dissent. When the judges go wrong, then they act against the constitution.
But my point is, from how I understand, there is the option of a review petition, an option of a curative petition. But once the Supreme Court of this country gives its judgment, I assume that after exhausting these legal options, it should be binding on all. That is the key point that should be acceptable to all of us.
I'll disagree. There is no estoppel against law. There is no finality of law. Finality is only on fact. Res judicata. There is no estoppel against law. There is nothing. That's a misconception. Then,
I don't know. The way we have understood all judgments of courts, particularly the Supreme Court, is final and binding on all.
No, I will quote a Latin maxim.
Because if we go by your logic, then the judgment on right to privacy, the judgment on the Ram temple, right, the Ayodhya title suit, everything could have been challenged. Post the options of curative. There will be no end to this.
No, they are mistaken. A judge is free to bind the parties before it. On a factual issue, a court is free to say 1 + 1 is 0 and it's binding. 1 + 1 is 0 on facts. The court says is 0, it is binding. But no, a court is also a servant of law. There is no finality of law. There is no estoppel against law. Legal issues remain infinitive. I will quote a Latin maxim. Res judicata facit ex albe nigrum. A judicial decision on facts can make what was white black. Ex nigro album. What was white black and what was black white. Ex recto curvum. What was straight curved. And ex curva what was.
Well, my point is. My point is, Mr. Nedumpara, let's see that once you follow the proper procedure as you were told by the Supreme Court, would you go ahead and appeal?
Then I will answer to that. There is no proper procedure. Article 137 of the Constitution, which provides for a review, is now dead. That letter, you file a review petition, it will never be listed. It is supposed to be heard in the chamber, and hearing of these review petitions are not even intimated. I filed a review petition in challenge of the judgment which dismissed my plea or my challenge the section 16 and 23(2) of the Advocates Act, whereby the senior designation system was created. And that petition was dismissed, review petition was dismissed.
Can I tell you something, Mr. Nedumpara? We just spoke to Mr. Aman Lekhi, who is the former Additional Solicitor General to this very government.
Yes.
And he seemed to suggest that Mr. Adish Agarwala's misadventure, who's the Supreme Court Bar Association president, your intervention, the intervention of Mr. Mukul Rohatgi and Mr. Tushar Mehta, all of what you were doing were saying separate things, but the string seemed to be common. That in some way, the court's order must not be implemented, or
The courts
there
are,
should be a delaying of the inevitable.
the
It was an
court,
exercise perhaps to delay the inevitable, and thus all of them seemed to be strung together. They appeared
no,
like different activities, but
I will
ultimately
answer in,
working to the same cause.
I asked one word, one answer, one word. The review
Yeah.
petition, if I file a review petition, it will never be heard, it will be dismissed in chamber. It's absolutely an exercise in futility. Absolute. That's what Chief Justice, when he said you file a application, Chief Justice certainly knows that no purpose will be served in serving that. And certainly, I entered into appearance for two reasons. Because the judgment is void, as a citizen of India, I consider the judgment of the Supreme Court to be void without jurisdiction. And
Okay.
as a representing as a party affected, then I felt this was judgment was rendered behind my back. No court has the power to pass an order behind the back of a person whose interests are directly affected.
Let's just hope that because of you, we don't sit in contempt of the Supreme Court
No, but
in this interview.
no, but I said that, but there's a principle. There's a principle. Let me quote a Latin maxim. Di fide officio judicis non recipito quaestio disentia serve sit ero judice serve facti. This is Roman said. So about the integrity and honesty of a judge, no questions can be raised. I did not question the honesty or integrity of the judge. But about the decision of a court, decency,
All
about his
right.
knowledge,
All
and
right.
his decision on facts and law can always be questioned. I did
Okay.
not, I did not criticize the judge. I did only criticize the
Sure.
judgment.
Well,
Which I,
let's just say that you've made your point in great detail here on this
yes,
platform. So
thank you.
thank you very much, Mr.
Yeah,
Matthews Nedumpara,
which
for
is
joining us.
one about I being shouting, etc. See, I'm 66 now, but I have a lot of energy in me.
Huh.
I speak. I speak with passion. That is my nature. That should not be taken as a shouting.
Is that your message to the CJI? Huh? I
Yes, you
wasn't
are.
shouting at you. I was just very passionate. And
That
then you
passion,
said, "No, I'm speaking softly." Huh.
no. It's my nature. I speak assertively when I'm personally convinced. And that is my nature. See, everybody, sometimes my eyes get closed. That when I focus, it happens. See, everybody has some disability. What I can do when I talk, I used to give dictation, keeping my eyes closed. So I try to change it, but I'm not
Sure.
may not going to be much of a success. So you must
Sure.
accept
Thank
me
you.
with all my limitations.
Well,
I am
I
not,
guess you have to tell all of this to the CJI, not me.
and
I mean,
I
I'm okay accepting you any which way.
no, look at my pronunciation also. I'm from my village. I studied, only after becoming a lawyer, I started learning English. So my English is not, the Queen's English or anything of the sort.
Oh, Mr.
My
Nedumpara,
pronunciation.
all of us they have our roots to the back to the villages. You
so,
know, come
so
on, it's okay.
my English is Malayalam. Some people say, accept with all humility.
Matthews Nedumpara, thank you very much for joining us. Thank you.
Okay, bye.